Good morning and welcome to the Special Magistrate Virtual Hearing Agenda for December 9th, 2020. All code officers have been sworn in at this time. Our first case is on page 1. Inspector James Fetter. Case number CE 20101022. Case address 407 Southwest 12th Court. Owner David Milchin. Property posted 11/13/2020. Posted at City Hall 11/26/2020.
Good morning, David. Can you please raise your right hand?
Yes.
Do you swear and affirm to speak the truth at today's hearing?
Yes.
Thank you. Go ahead, James.
James Fetter for the City of Fort Lauderdale Code Compliance, presenting case CE 20101022, property located at 407 Southwest 12th Court. I inspected the property on 10/24/2020 and cited for the following violation: 1812A. There's overgrowth consisting of grass plants and weeds on this property and swale areas. I issued an inspection report allowing 10 days to come into compliance. I posted the inspection report at the property and took photographs. I re-inspected the property on 11/5/2020, found the violations remain as depicted in the photographs. Schedule for today's hearing, the city is requesting 7 days and a fine of $100 a day for the violation.
All right, on behalf of the owner.
Hey, my name is David. I'm only looking at photos that weren't submitted by me. Before we begin, if we could pull up the photos that I submitted that shows the line where the sidewalk is, and then I submitted as evidence my property survey. I moved in February, and it's pretty clear that anything past the sidewalk is the city's responsibility.
Okay, Ms. Montoya.
Waiting for him to. The property owner's responsibility is all the way to the edge of the roadway, whether it's on his property or not. That's standard practice for all cities.
Guys, I'll just be very frank here. It's either my property or it's not. If it's my property, I got turf grass inside my fence for a reason. I don't have time to be dealing with this grass. If it's my property, great. Just give me something saying it's my property, and I'm going to turn that into not what it is. But according to my property survey, that's not my property. Same reason why I couldn't turn that into a parking space. It is shows right here on my survey, and that's submitted, that it's not my property. As far as standard practices, I don't really know what that means. When you're buying a property, you pull a survey for that reason. So I can't go and install something I'm not allowed to install on that land.
Ms. Montoya.
Yes, thank you, Your Honor. Rana Montoya Hassan with the City Attorney's Office. Your Honor, as you well know, and I think as most individual people know, it's areas, as the inspector said, outside the property. It's not just standard practice, and we can always adjourn, and I can look for the legal section. Is the property owner is responsible. The city certainly is not responsible for maintaining that piece of land. Similarly, and by analogy, Your Honor, the swale is not technically owned by a property owner, yet we all know, not just in Florida, but probably the United States of America, that owners have to maintain the swale, but at the same time, they're not allowed to do certain things in the swale, i.e. parking in the swale, planting certain trees or bushes or shrubs or flowers, certainly may not be a part of a survey evidencing the curtilage of the property, but the property owner is still responsible for maintaining that as well.
In Your Honor, if I may add, Portia Williams, Co-Compliance Manager for the City of Fort Lauderdale. Section 18-12A that specifies about property clearings and nuisances specifically includes swell areas as a part of the property owner's responsibility for maintenance. So it's not just practice, it's actually in the code that the property owner is responsible for maintenance of the swell.
Okay, so if I don't want that to be grass and I want to turn it into rock per se, am I allowed to do that? I'm just not understanding how it's not my property and you guys are not an HOA, but you're allowed to tell me I have to spend $75 a month to pay someone to cut that. Because I sure as heck am not going to get a lawnmower and do that.
City's position is well taken. I find the violation does exist. 7 days to comply, $100 per day thereafter.
Thank you.
Thank you. Our next case on page 1, Inspector Paulette Del Grosso. Case number CE 20100075. Case address 1400 Northeast 16th Court. Owner MDR Motors LLC in care of Michael Greco Jr. Property posted 11/17/2020. Posted at City Hall 11/26/2020.
Good morning, Your Honor.
Good morning.
One second,
Paulette,
please. Good morning, sir. Can you please raise your right hand? Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you so much. Go ahead, Paulette.
thank you. Paulette Del Grosso for the City of Fort Lauderdale, presenting case CE 2010075 for property located at 1400 Northeast 16th Court. I inspected the property on October the 16th and cited for the following violation, 18-12A. There is overgrowth, trash, and debris on site. I posted the property with a 10-day nuisance notice and informed the general manager of Greco Motors, who is appearing today, that I would set the matter for special magistrate as a recurring violation. The property is a recurring violation per cases CE 1806-0544, CE 1809-1628, CE 2006-1121, and CE 2001-1684. The property has been cited for the same violation numerous times. Therefore, the city is requesting a finding of fact that a recurring violation exists based on this case as well as the previous 4 cases for the same violation, and a $150 daily fine should the property become overgrown following today's hearing.
All right, on behalf of the owner.
Good morning, Your Magistrate. Can you hear me well?
Yes.
Okay, so I submitted some pictures. I don't know if you can see them from the surrounding area. This particular picture, exactly where the swale is and the hedge is. And I should start by the fact that after speaking, and receiving the original code violations, we have increased the frequency of when we have our lawn service go out and mow and trim the hedges. With that, if you look at the pictures that I forwarded via email, you will see that it just becomes difficult at some times because all of the adjacent residents park their vehicles, particularly on this side that needs to be mowed and so forth. And there's a line of vehicles all the way across. I don't know if you've seen those vehicles. So we do the best we can when we get there with some of the vehicles, ask them to move them and so forth. And, sometimes we can find them, sometimes we cannot. I do agree with the officer that particularly during this past wet, rainy season, there were a couple of times that we were delayed just because we could not get in there and get out. The other issue is that obviously, because we're a commercial property there and there's a lot of homes, as a property per se, I know we're just picked on more because we're commercial. But if you look at some of the surrounding homes that I sent pictures of, they let their landscaping get into as bad conditions or even worse. Some of them don't even take care of it. So I think it's just a little bit unfair because of just some of the residents, particularly picking up the commercial property. But I do want to express the fact that we've done everything. We've increased the frequency and we're trying to maintain it. The biggest issue sometimes is when we get there, that obviously there are vehicles parked all the way along that swale and we can't access everything that we need to do to trim. And for that, I ask that we waive the fine and just let us go forward and maintain it as best we can. And I don't know if there's something we can do to keep the residents from parking so we can maintain the hedges in that area best. The one part of the hedges is that they are mostly on the outside of the fence, so you can't really trim them from our inside of the property properly.
All right, Mr. El Grosso, the city's request is for a finding of fact that the violation did exist, correct?
Correct.
All right. Okay, I make that finding of fact that the violation did exist, and there was some more to the city's request.
Yes, Your Honor. I realize that that Greco Motors is attempting to increase the frequency of cutting the swale. And to his point, cars often do not park along Northeast 16th Court, and that's the area that provokes the most frustration amongst the neighbors. That strip of land is what people are looking out and seeing directly in front of them, and it's often overgrown. It's not from any one particular rainy season. This has been happening since, as far as I've been assigned to the neighborhood, since 2018, as the cases indicate. Therefore, the city is requesting the finding of fact, and should the property become overgrown in the future, then a fine of $150 a day should be appropriate.
All right, okay. All right, the city's request is granted.
Thank you, Your Honor.
Thank you.
Our next case is on page 12. Inspector Gail Williams. Case number CE 20110142. Case address 1467 Northeast 53rd Court. Owner AOG Investments LLC. The property was posted on 11/17/2020 and posted at City Hall on 11/26/2020.
Okay.
Good morning. Can you please raise your right hand, Brendan? Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you so much. Go ahead, Gail.
Good morning, Your Honor. Inspector Gail Williams for the City of Fort Lauderdale, presenting case CE 20110142, address 1467 Northeast 53rd Court. Inspections of the property were performed and cited for the following violations: 15-282, parentheses D, parentheses 1B. There are a qualifying number of violations at this vacation rental property to request a certificate suspension of 365 days before the special magistrate. On May 4th, 2020, the property was cited for violation 18-1 for people being at the property during the suspended time period of COVID-19, referred to case CE 2005039. On August 17, 2020, property was cited for violations 18-1 for people and vehicles being at the property during emergency order and without on-site management or security, referred to case CE 2008060. On October 15, 2020, property was cited for violation 24-27 parentheses B for recycling bins left out at curbside on trash pickup day, refer to case CE 201-00610. On October 30th, 2020, property was cited for violation 18-1 for a large group of 30 or more people found at the property for a Halloween party. Refer to case CE 201-01322. Citations were posted on the property and mailed first-class mail to the owner listed in Broward County Property Appraisal. Contact was made with the owner as well. The city is requesting the vacation rental license for this property to be suspended for 365 days.
All right, on behalf of the owner.
Good morning, Your Honor. I'd just like to start off and mention that we live in Montreal, Canada. We bought this property in May of 2019 for personal use and for vacation rentals. We are extremely picky with the people that we allow to use this property. It is far from being a party house. We do not accept young people in large groups to use our house. We primarily rent to families that want to come to Sunshine City and enjoy the good weather and everything that Fort Lauderdale has to offer. Regarding the garbage issue that was cited, as far as we know, obviously we're not on site. We have different crews that take care of the property. We have a cleaning crew, we have a poolman, we have a handyman, and we have a landscaping company that makes sure that our property is well maintained, that looks good, and is something that the neighbors and that we feel proud to have out there on the market for short-term rentals. So regarding this garbage citation, it seems to be an issue that was not reoccurring, and it was just the recycling bin that was left out a little bit longer than the permitted times. The inspector spoke to the cleaning crew and mentioned to them that the garbage needed to be brought in, and for a reason that I do not know, it took an extra day for those bins to be brought in. The bins were empty. There was not garbage or rubbish or anything of that nature spread out on the lawn or on the road. It was simply the bins that were there for a period that seems to be a little bit too long. So I don't think that's a major issue. I think it's a case that was addressed as quickly as it could, and it hasn't happened since. So we've addressed that with the cleaning crew that is responsible for bringing in and out garbage and recycling after the short-term rentals. In regards to the Halloween party, we had rented to a group of 5 people. And again, I'm going to repeat myself on this. We are extremely picky who we allow in that house because we don't want parties and we don't want any loud noise or music and whatnot. So we have a system that we use to filter who we allow in that property. And we did so for the rental on the Halloween date. I don't know the exact dates, but it was approximately, I believe, the 28th or 29th of October. They were supposed to be 5. We had their IDs. We had all the information cross-checked. And it was supposed to be a very mellow 5-person rental. Throughout the evening, we checked our cameras and we realized that there was a large amount of people in the house and that there was a Halloween party. We obviously could not make it there because we were with our families in Montreal, Canada. And so we called the police and we asked the police to go there and address the situation to the person that we rented to. And the police said to us that they couldn't do anything. They needed a representative on site. And that's when they called the inspector to go on site. And we were on the phone and we participated in the entire procedure of getting these people out of our house, because that's not what we rented the house for. And again, this is not something that is reoccurring. We are very strict on the amount of people that are allowed in that house for the rental property. So that's regarding that citation. Now, the other citation regarding the rental during the COVID period, it's very hard for us to follow the different rules that change every week. There were some areas that said there was a number of family members. Others gave a maximum of people that could be there. But basically, it became very hard for us to follow all these rules. And as the rules changed, and we ended up having a rental that didn't respect a portion of the COVID regulation. And that was a surprise to us, because we were under the impression that we were respecting all of the regulations and that we weren't in default in regards to those regulations. So again, it was a one-time issue. And as I said, it came as a surprise to us that we were not respecting the rules. We addressed it and people left. There was a fourth citation that I didn't quite get, Gail. I don't know if you can maybe refresh my memory on that fourth citation.
And which one is that?
Well, we did the garbage, we did the COVID rental, we did the Halloween party, and there seemed to be another one, but I'm not aware of it.
You're speaking in reference to the one on August 17th, 2020?
I would imagine, because I feel that I've covered the three other ones.
Because at that present time, there were people found at the property. And during that time frame, there was no on-site management or security during the emergency order. And that's the reason why the property was cited.
Okay. So that's, yeah, so that basically covers the issue we had with following all the different rules that were changing so rapidly. And we got, I guess we got caught up in change of rules that we didn't see go by, and I guess the property was rented during that period when it shouldn't have been. So I guess that's our bad for not being able to follow all the different rules that have changed. I think we can all agree that it is a very complicated situation, and that there are a lot of rules, and the rules change very quickly. And our goal, as I said, is not to break those rules. It was just hard for us to follow, and it put us in a position where we had people there that we didn't know weren't allowed to be there. So that's kind of where we stand on these different citations. As I said, it's hard for us to manage everything perfectly from Canada. But the property is rented for probably the next 2 months. It's a nice property, and it's well maintained, and we're proud of the way it's handled. There's a couple hiccups here that have happened, and as soon as they do happen and that we're informed of them, well, we address them as best we can.
Your Honor, if I may, Portia Williams, Co-Compliance Manager for the City of Fort Lauderdale. So a few things. The city's code for vacation rentals requires property owners to have a responsible party that's able to actually come to the property whenever there's an issue, and that really is expected to maintain and kind of corral the guests there. Mr. O'Dowd basically is stating, or I heard him state earlier, that he contacted the police and participated in the police evicting or getting the guests under control. That's what the responsible party is supposed to do. In terms of the ordinances changing throughout, or the orders changing throughout the last few months, I completely agree. And throughout the last few months, each time the ordinance changed or the orders changed for vacation rentals, an email was sent to responsible parties and property owners of vacation rentals throughout the city, and the major changes to the orders was highlighted in those emails. I respect the fact that the owner lives in Canada. However, the residents here in Fort Lauderdale is who is affected whenever we have people coming to vacation rentals. and not adhering to the policies within the city, especially during this time when so many communities are concerned with people coming to Fort Lauderdale or coming here from other places and having parties or gatherings and infecting other people that actually reside here.
Ms. Montoya, did you want to add anything?
Thank you, Your Honor. Ronald Montoya Hassan with the City Attorney's Office. I would just add, Your Honor, that all of the violations and citations that the inspector has brought forward in support of the year suspension have already been found to be valid, i.e. the citations have not been appealed, violations have already been found as a matter of law. We also know, Your Honor, that early on in the pandemic, it was clear, very clear, not confusing, that vacation rentals were prohibited, and certainly parties, large gatherings of parties have always been prohibited and continue to be prohibited. So there's really shouldn't be any confusion with regard to those issues. So I would just say, Your Honor, that the four citations and violations as listed by the inspector have already been found to be valid and are thus supportive of the city's request for the suspension.
Not only do we have multiple violations, we've got public health issues here. I am compelled to agree with the city's position and grant the city's request for a 365-day suspension of the certificate. Thank you.
Thank
When
you,
is
Your Honor.
this suspension effective?
You will be notified via mail and email in reference to when it will start.
You're unable to tell me that at this time?
Correct.
It's today.
Right.
It's going to start today.
I'm sorry, Portia, go ahead.
I believe it would be today. That's the day that the magistrate is ordering that it's suspended, so today.
So what are we supposed to do with families that have rented for holiday season?
That's a business decision. If you're found operating during a time where your license is suspended, then you're going to subject yourself to additional fines and penalties.
So you realize that we're going to be scrapping people's holidays?
Your case is heard, sir.
All right, thank you.
Thank you.
Thank you. Next case, please.
Our next case is on page 5. Senior Inspector Manny Garcia. Case number CE 20050544. Case address 3670 Southwest 23rd Court. Owner Riverland Road LLC. Property posted 11/15/2020.
Need help?
Posted at City Hall 11/26/2020.
Good morning, Your Honor. For the record, Manny Garcia, Senior Inspector for the City of Fort Lauderdale Code Compliance, presenting case CE 2005.
Manny, 1 second, please.
Oh, I'm sorry.
Thank you.
Mr. Howells, good morning. Can you please raise your right hand?
Yes.
Do you swear and affirm to speak the truth at today's hearing?
Yes.
Okay, thank you. Go ahead, Manny.
Good morning, Your Honor. For the record, Manny Garcia, Senior Inspector for the City of Fort Lauderdale Code Compliance, presenting case CE 2005-0544 at the property 3670 Southwest 23rd Court. On May 22nd, 2020, complaint CE 2005-0544 was received from Southwest 23rd Court that was operating as a drug rehab or adult living facility. On May 27, 2020, the property was cited under the following violation: 47-18.47A. This property has been identified as a community residence. They have not registered with the Planning and Zoning Division of the city as required, nor have obtained a state certification. An email address was obtained of the property owner, Mr. Howells, in which I sent an email advising Mr. Howells of our findings and the violations regarding his property. A copy of that email is attached to the photographic evidence for your reference. Furthermore, I reached out to the FAR, which is the Florida Association of Recovery Residences, and they stated that Mr. Howell has submitted an application for certification, which was withdrawn in 2019. On May 27, 2020, Contact via phone was made with Mr. Howes, in which he stated that he's not using the property as a drug rehab or halfway home. Mr. Howell stated to me that he has been renting out the property to individual persons. After further research, a profile was discovered on Facebook providing Riverland Recovery with a photo of the property stating halfway house, saving and changing lives one day at a time, and post stating men's sober living house in Fort Lauderdale, as depicted in the photos. In addition, a Sunbiz LLC registration of Riverland Road LLC with the address 3670 Southwest 23rd Court, and last, Riverland Recovery LLC with the address 3670 Southwest 23rd Court, as depicted in the photos. As of today, the property remains unregistered with the city of Fort Lauderdale. The city is requesting 34 days for compliance, or 100 days, $100 per day per violation until the property has been brought to compliance.
On behalf of the owner.
I'm here, sir.
Okay.
Can you hear me?
I can hear you. Your turn.
Okay. I'm willing to do whatever I have to do to comply with the city. So whatever we have to do within 34 days, we're willing to do that. We did re-register with FAR. The paperwork is being submitted with FAR. So we're in the process of that. So whatever we need to do to comply, I'm willing to do that.
All right, very good. For the record, I found the violation does exist. 34 days to comply, $100 per day thereafter.
Thank you,
Okay,
Your
so what
Honor.
do
Thank you.
just go to the city and find out what it is, or can you tell me now?
Mr. Howells, you can go ahead and give me a call. I think you have my phone number. So you can give me a call and I'll walk you through what you need to do.
Yeah, you've been chasing me for 3 years, sir. 3 years. I'll call you. Thank you so much.
Have a great day.
Our next case is on page 14. Inspector DeAngelis Gibson. Senior Inspector Dorian Cologne presenting. Case number CE 19052379. Case address 1711 Northwest 7th Place. Owner Abraham Shakur. Case was first heard on 11/7/2019 to comply by 12/5/2019. Suspended 3/5/2020 to 3/15/2020 and 3/16/2020 to 9/4/2020. 3 sections complied at $50 per day. $13,050 accrued. 1 section not complied at $50 per day. $9,350 accrued. A total of $22,400 accrued. The city is requesting full amount be imposed and fines continue to accrue on the non-compliant violation.
Good morning, Mr. Harrison. Please raise your right hand. Do you swear and affirm to tell the truth at today's hearing?
Yes, I do.
Thank you so much. Go ahead, Dorian.
Hi, good morning. Senior Inspector Cologne for the City of Fort Lauderdale on behalf of Inspector DeAngelis Gibson. Case number is CE 19052379. The case address is 1711 Northwest 7th Place. This case came before the special magistrate on November 7th, 2019, where evidence was presented and the magistrate found for the city, giving 28 days to comply or a fine of $50 a day per violation thereafter. And this case came before the special magistrate again on March 5th, 2019, where the magistrate granted an extension of 10 days. There was also an extension given due to the pandemic between March 16th, 2020 through September 4th, 2020. And there was a total of 10 inspections made to this property. Upon some research, I discovered that 9305B actually has been complied. It was complied on March 13th, 2020. So therefore, all the violations are in compliance as of that date. And the city is requesting a reduction in costs. And the city is requesting that reduction to be in the amount of $3,000.
Okay, on behalf of the owner.
Yes.
You understand what the lady said?
Yes, I did. Yeah. The only reason that we had there was any problems is because it was lost in translation. We didn't know there was a problem with the property and the tenant, which we still have in there because we can't get her out because of COVID. But she wasn't relaying any information to us, so we didn't know we had a problem. As soon as we found out about it, we took care of it as soon as possible.
Your Honor, so
Yes.
looking at the case, these violations were out of compliance for, 3 of them were out of compliance for 87 days. And then the last one that was complied on, 313 was complied 13 days after that. So shortly after the 87 days. And this case was opened in 2019. So the cost that we're asking for is actually actually a little bit less than the 20%. So, just keeping that in mind, the city is requesting that reduction.
All right, I'm going to grant this reduction to $3,000.
All right.
Thank you.
Thank you.
Thank you.
Our next case is on page 17. Inspector Gustavo Caracas. For case number CE 190811100, for case address 666 West Broad Boulevard, owner Burger King Court number 3 in care of Ryan. This case was first heard on 1/16/2020 to comply by 3/19/2020, suspended 3/16/2020 to 9/4/2020. 4 sections not complied at $250 per day, $96,000 accrued. 1 section complied at $250 per day, $17,250 accrued. A total of $113,250 has accrued. The city is requesting to vacate the order of October 18th, 2020 and rehear the case.
Okay, so the city's request is we vacate the order of October 18th, 2020. Okay, that request is granted and that order is vacated. But we still got, is anyone here on behalf of the owner?
I'm here, Your Honor. Do I need to be sworn in?
Okay. Good morning, Russell. Please raise your right hand. Russell, please raise
Yes, I'm here.
Please raise. Okay. Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you so much. Go ahead, Gus.
All right.
Good morning, Your Honor. Officer Caracas for the city of Fort Lauderdale. Case number CE 190811100 for 666 West Broward Boulevard. As you heard, the owner of the franchisor he wants to give his side of the of why he hasn't come into compliance. Sir, if you want to elaborate a little bit, please.
Absolutely. So we had submitted information and permits and approvals and got them back in 2019 to remodel the restaurant. Subsequently, we found that the city came to us and said that this is the gateway to downtown Fort Lauderdale and wanted to do a lot of additional work that was not a part of our original scope. We had to be patient and waited several months, and I mean several months, almost up to a year, and for the state and the city to reconcile how that was going to be, because we border both the state and city roads. We've also got 2 additional permits, one to redo the entire property as it states with landscaping. They would like the city would like a water tower at the hard corner, re-landscape the entire property, change the entire look of the property, as well as we're going to be tying into city sewer system at the same time. It took several months. I forwarded all those email chains to the inspector and showed him that for months on end, we had been waiting for decisions to be made by the state and the city. And finally, those decisions were made late last year. We completed the remodel and had issues with the city tie-in with the sewer system. That still has not been permitted. We're still trying to get that thing out of permit, but we just need a little bit more time. We have complied with everything except for that picture right there. That tie-in is going to be done by this Friday. The general contractor got his roofing inspection and got approved to finish the roof, and could not do that until he was actually completed with the permit. So we have addressed all the trash that's ongoing. This was back done on I believe 12/8. So this morning, those were all taken care of. We constantly are in the restaurant or outside the restaurant picking up trash. There's a lot of homeless people in this area that we're continuing to pick up. But as you can see, we've updated the chain link fence. We've fixed the landscaping issues, and we continually roving through getting all of the trash out of the property as frequently as we can get out there every day. But there's a very large homeless presence in the area. We will begin construction on the property as well as all the landscaping. I submitted those plans to the inspector, and that shows that all of the landscaping buffers are going to be extended. We're going to be losing parking on the the northeast side of our property, and that will become a nice thoroughfare, as well as we're going to be redoing the whole landscape of the parking lot after we've done the city tie-in with the sewer system.
All right. Well,
We're requesting an extension for a 6-month extension through June 30th of next year.
This has been going on since January of this year. You've got a number of violations that are not in compliance. I'm going to grant the city's request that the fines are imposed and continue to accrue. I can listen to all of these details at a future date once you come into compliance.
May I speak at all, or are the rulings finished?
Okay, I'm sorry. Let's go back to the will be May 27th, 2021, which is a Thursday. So I'm going to stay the fines as of this date, grant an extension until May 27th, 2021 with a mandatory reappearance.
Thank you very much, Your Honor. I very much appreciate it. Thank you very much, Ms. Williams and Gustavo. Thank you.
Thank you very much.
You're welcome.
Our next case is on page 2. Inspector Bovary Xantis, case number CE 20080428, case address 1540 Northwest 11th Way, owner Rodolfo Casada and Judith Gutierrez. Nope. I apologize, Bovary, your respondent has not made it into the room. So we're going to call Karen's case next. We'll put you on recall. Our next cases are on pages 15 and 16. Inspector Karen Proto. On page 15 is case number CE 19071977 for case address 2713 Northwest 20th Street, owner Louis McCutcheon. Case was first heard 11/7/19 to comply by 2/6/2020, suspended 3/16/2020 to 9/4/2020, and 10/14/2020 to 12/9/2020. 3 sections not complied at $50 per day, $11,700 is accrued. On page 16 is case number CE 19071973. Case address 2709 Northwest 20th Street, owner Louis McCutcheon. This case was first heard on 1/16/2020 to comply by 1/26/2020 and 2/20/2020. There are 2 suspensions notated on the agenda, 7 sections not complied at $50 per day, $12,450 accrued. The city is requesting full amount and fines continue to accrue, and this was in order to reappear.
Good morning. Could you please both raise your right hand? Louis? Looks frozen.
Yes.
Do you swear and affirm to speak the truth at today's hearing?
I do.
Thank you.
Good morning. Inspector Proto presenting behalf of the city.
I do.
I can't hear.
Good morning.
Okay. Inspector Proto in presenting behalf of the city. Case, somebody's talking like this. Okay, case number and address is read into the records. This case came in before Special Magistrate on November 7, 2019, where the evidence was presented and the magistrate found for the city. The violations were first cited on 7/25/2019. A total of 20 inspections were done on the property. A 56-day extension was granted on 10/14/2020 at Special Magistrate. The case is not in compliance and the violations remain. It is in the position of the city that the fines be imposed as read.
All right, on behalf of the owner. Ms. McCutcheon?
That's our time to chime in? Yes.
Anything you would like to add?
Let me talk to me. Hello? All right. From my understanding, when my grandfather had got the last court date, he had just got out the hospital from a fracture fall. Recovery time. He was recovering and he had no one to assist him in the yard at the time, nor he was able to have anybody. He would come in. He requested that I come in and assist to move out the things that was in violation. I had moved some of the things out, and I had pressure on his funding. Man, he requested that I come in and move some of the things out, and I most allowed time so he can get into compliance due to the fact that he's 93, and this second fall took him out physically where he's unable to do anything long as his income.
This has been going on for over a year. And you've got got 3 not in compliance. You got an extension, still didn't come into compliance. I'm going to grant the city's request that the,
those times he was recovering and he had no one to assist him in the yard, but all his fun. But he had 2 faults, from my understanding. And the previous fall is where it took him out physically. And then I got requested to come in to help him out recover and requested that I come in and comply. Come out physically, come out like the city, people come out to remove the tires and to remove the certain things. No one has showed what had happened when I was trying to get people to come out like the city to get stuff removed out, where people to come out like the city with certain things. No one has showed to get the stuff removed out, to move this stuff out manually. And with his limited income and his ability not to be out there with me, basically, I'm basically left to do all the stuff by myself. And we just asking for more time so I can get him into compliance before you guys start imposing those liens and stuff.
we did that one time. Okay. I'm going to grant the city's request that the fines be imposed and continue to accrue. Okay. I need like a 5-minute technical recess here. I'd like to see
Thank you.
tech gentlemen That's fine, because we still got the same situation, multiple non-compliances going back over a year. So same ruling applies to both cases.
Okay, thank you, Magistrate.
Thank you.
Our next case is on page 8. Captain Robert Kersarwich. Case number FC-19120011. Case address 5809 North Andrews Way. Owner Elizabeth Morris Avenue Center Associates LP. Personal service was given to this property on 11/20/2020 and posted on the property at 11/26/2020.
Yeah. Hey, good morning.
Good morning. Please raise your right hand. Do you swear and affirm to speak the truth at today's hearing?
Yes, ma'am.
Thank you. Go ahead, Kersarwich.
Good morning, Your Honor. Captain Robert Kersarwich, Fort Lauderdale Fire Marshal's Office. Here to present case number FC-19120011. Property address of 5809 North Andrews Way. Property was cited in reference to NFPA 1 4.5.8.6. The fire alarm system has not been tested, inspected, and or tagged in accordance with the code. Currently, right now, situation with the fire alarm is there's actually no power going to it, and it looks like it's been disabled at this point. Property management or representative that we have right now might be able to give us further information about where they plan on going, how they plan on getting an alarm contractor in here to bring the system back up online, or what their intended purposes for the alarm system and the structure is going to be in the future.
Good morning, Robert Shahady for Elizabeth Morris Avenue Center, the owner of this property. I spoke with Mr. Kersarwich on, I believe it was Friday last week, and we had a good conversation. We've already spoken with, the owner has spoken with contractors and has a bid to have the system removed. In order to do that, my understanding is we need to have a permit approved by the city and obviously do the work. That being said, we'd like some time in order to submit the permit, but then obviously we're going to need some time additionally to complete the process, depending on how long it would take. But it is our understanding that the building does not require this system. The system was installed by a prior tenant over 4 years ago, and that the property actually sat empty for that time until recently, and the new tenant that's in there we're having an issue with. So that being said, we want to remove it since it's our building and we're going to have to pay for it. We'd like to remove it, and of course, again, we're going to apply for a permit. We just need time to obviously accomplish that.
Your Honor, one of the options that they have in front of them would be to apply for a permit to show that the alarm system is not going to be a required function by code for the occupancy structure any longer. If that's the case, the permit gets approved, then the process would include a removal of the entire system. So there is no components or no evidence of the system still within a structure, not giving anybody a false sense of security that the building is still being protected by a fire alarm system. So with that, it would be the remote annunciators, the horn strobes, the pull stations, the fire alarm panel, all components of it would then need to be removed. The permit would be signed off and approved. And then of course we could put the case into compliance state based on that. At this point, I'd recommend 62 days in order to get the process started and get a contractor out there to get that done, or $100 a day thereafter.
All right, let's do that. Let's get the process started. So for the record, I found the violation does exist. 62 days to comply, $100 per day thereafter.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Our next case is on page 10. Captain Robert Kersarwich, case number FC-20090010. Case address 17 South Fort Lauderdale Beach Boulevard. Owner Thor Gallery at Beach Place LLC in care of Ryan LLC. Divina Tavares. Personal service was handed to this property on 11/19/2020 and posted at City Hall on 11/26/2020.
Good morning, Michael. Can you please raise your right hand? Do you swear and affirm to speak the truth at today's hearing?
Yes, I do.
Thank you very much.
1 second, Lauren, there's also an attorney for this case as well.
Okay.
Hello, can you hear me?
Yes, we can. 1 second, please.
Okay, on behalf of the city,
We're waiting for the attorney. We're waiting for the attorney. We're waiting for the attorney.
oh, okay.
I don't see anything.
Part of it.
Good morning, Mr. Tipple. Can you please raise your right hand? Do you swear or affirm to tell the truth at today's proceedings?
I do.
Thank you.
Good morning, Your Honor.
Good morning.
Captain Robert Kasarowicz, your case number FC 2009-0019. Property address is 17 South Fort Lauderdale Beach Boulevard. We conduct annual inspections at this property, but the last annual inspection was conducted on 7/28 of 2020, with subsequent inspections on 7/30 of 2020, 8/31 of 2020, and 9/16 of 2020. Before this case was created and heard in this court, the property was cited for the following violations. F-111 1.3, the smoke control system has not been certified annually by Broward County Test and Balance Company. Municipal Order Section 9-313, address is not posted in accordance with the code. NFPA 1 13.3.1.1, the fire sprinkler system is in need of service. NFPA 1 4.5.8.6, the fire alarm system has not been tested, inspected, and or tagged in accordance with the code. NFPA 1 13.3.1.1, discussion rings are missing. NFPA 101 7.10.5.2.1, the exit signs do not illuminate as designed.
Hello?
NFPA 101 7.2.1.8.1, self-closing or automatic closing doors do not self-close and latch. NFPA 101 7.2.1.5.3, locks provided in the means of egress require a key, tool, or special knowledge or effort to operate from the egress side. NFPA 101 7.1.3.2.1, there are unpermitted penetrations and or openings into and throughout the exit enclosure assembly, mainly the stair. NFPA 1.11.1.2.2, electrical wiring is not per NFPA 70, the National Electric Code. NFPA 101 7.2.1.4.5.1, the exit door requires too much force to open. NFPA 1 1.7.7.2, the alarms trouble alarm is showing on the fire alarm panel. The next violation on your agenda you might see 1 is listed as withdrawn. It's duplicated. So there is only one fire code violation for NFPA 113.2.3.1. The standpipe system is not being maintained and at least the same level of performance and protection as designed. And NFPA 1.12.1. All required permits and inspections have not been done or passed. This property sits on the beach and is subjected to a heavy salt corrosion environment. There is a tenant that is occupying one of the spaces in this building occupancy where they obtained permits to do a complete build out for a wedding hall venue operation. They have never received final approval on the main master permit, the fire sprinkler permit, the fire alarm permit, the mechanical permits, but are continuing to operate the business without obtaining such approvals. They also do not have an occupational license from the city of Fort Lauderdale, as they were unable to final out these inspections. The fire marshal's office had worked with that tenant space in particular in order to keep them operational because, again, these are just a lacking of final inspections on permits. The fire marshal didn't see it to be egregious enough to use the state statutes for ordering a termination of power on the unit. However, the business continues to operate without moving forward on finalizing the permits. We did provide fire watches and had communications with the owners of the tenant space who have the lease agreement with the property representatives that are here to allow them to finish up with the weddings that they currently had scheduled. At that time, they were not going to move forward with booking any future events. And we did provide the fire watches to get them through 3 events. That bill, and those occurred back in July of 2019, went unpaid up until just the other day. I guess as this case moved forward to be presented to this magistrate today, they started making progress and making an attempt to get everybody together and to come into compliance with it. I had a very good phone conversation yesterday with legal counsel that's here today representing the case, property management, a couple professionals from the industries of the sprinkler contractor was on that call. And we spoke in reference to a game plan of how they were going to move forward and bring this property into compliance. And I think at this time, it would be proper for them to introduce themselves and to let the magistrate hear what they have to say about putting the property into compliance.
Captain, you have to recommend, though, a time frame and a fine, please.
Well, at this time, I think for today, I'm going to want to keep this on a little bit of a shorter leash. This isn't something that occurred overnight. This has occurred through a lack of maintenance for an extended period of time. So I'd like to see a reappearance on this case within 62 days. And I also would like to ask for $250 a day per violation, with the exception of NFPA 1.12.1 for the occupancy of that tenant space prior to approvals on the permits. Or they don't even have, of course, the business tax license at this point. And at that violation, I would like to ask for $1,000 a day on that one.
Repeat your recommendation again.
My recommendation would be 62 days for reappearance, $250 per violation, with the exception of NFPA 1.12.1 at $1,000 a day for that violation.
All right, on behalf of the owner.
Good morning, Magistrate and city staff members. This is Steve Tilbrook with Ackerman Law Firm. We represent Thor Equities, that is the owner of the Beach Place. Beach Place is a long-standing staple of the beach redevelopment environment. Was the first beach redevelopment project on the beach. We're here to represent the owner. We do not represent the tenant. We know there's been issues with the tenant, and I'll get into that in a second. We received notice of this, and I know there's been some inspections that have occurred since July, but we didn't receive notice of this till November 19th. Since then, we've been taking action to achieve compliance, but Captain's mentioned these are some significant matters that are going to require some time to achieve compliance. You can see from the photographs, we're not here to dispute the condition. These photographs speak for themselves. We are committed to undertaking a process to bring the property into compliance. It's not going to be an easy or a quick process. And I just want us to all go into that, with eyes open, that this is going to take some time and a little bit of a partnership. Since we received notice, we've engaged professionals, smoke testing, fire alarm testing, engineering professionals to look at the building and do inspections. And I submitted also estimates for door work and other work exceeding several $100,000 that I just submitted today to show that we've actually been receiving estimates. It's going to take time to coordinate, get permits, and implement this work. We don't have any problem coming back in 62 days. That's the arrangement that we coordinated with Captain Kasarwich. We know that this is kind of a quote unquote short leash at this point to get the work done on behalf of the property owner. We are committed to a partnership with the city to get that work done to the best extent that we can as quickly as possible. It's not going to be completed within 62 days. I think there's a good number of these items that are already in compliance. We just need to have an inspection, and we will receive sign-offs on a number of. There's actually 15 citations here. That's a lot of citations. If you calculate up, so we're going to do our best within 60 days. I would say a good number of these will be within 62 days, but certainly not all of them. Not all. There's a number of them that could go on for 6 months or more, because obtaining a permit, getting the contractor, that type of thing is going to take some time. We're willing to undertake mitigation measures in the meantime, just to make sure that we have a safe and functioning environment there. If you add up our main concern at this point is not the 62 days, not an issue about whether or not there's compliance. There's clearly not compliance on certain things, but we are in a significant economic recession. We're in a COVID environment. Many of our tenants have left. We're struggling getting our tenants to pay. And if you add up all these 15 violations at $250 or $1,000 a day, that results in a potential fine of nearly $5,000 a day, which is egregious and is too much. It's just too much in this environment. So we would ask the special magistrate to have a reappearance within 62 days and fines of $100 a day for each of the violations.
We'll address the issues. I think everybody is in agreement that you got a mess there, and it's going to likely take more than 62 days. I'm going to follow the city's recommendation for 62 days, $250 per day. Thereafter, we will see the progress that's being made and be very reasonable in dealing with reasonable extensions based upon the progress that's made.
Your Honor, you may recall the captain asked for the last component of the violation to have $1,000 a day fine.
And we would just ask for reasonable. We would just ask for reasonableness in the amount of fines. I mean, These are significant fines. This is not a minor amount of money for anybody. And we would argue that $100 a day is more than sufficient, considering that we just got notice on 11/19. We've already taken significant action. $100 a day is sufficient to get our attention and to get this thing done.
But the fines have not started to run.
Exactly.
Okay.
When would they start to run?
Counsel, you've never been through the magistrate process?
I have. I just want to make sure they're not going to start to run in 63 days.
Counsel, you know there has to be a Massey hearing before there's any imposition of fines.
All right, we're going to keep, I guess, coming back on this with
Correct.
progress reports and
Yes.
coordination. And we expect that, we'll just have goodwill on both sides, that as long as we make progress, we're going to not have an imposition of fines, and there's going to be sort of a partnership going forward.
All right. The city is obviously going to work with you 62 days, with the exception of the last one as requested by the city.
I can't hear the special
Okay.
magistrate.
Reappearance on February 9th, 2021. Thank you.
Thank you.
Okay.
Thank you. Our next case is on page 7.
Thank you.
Inspector Will Snyder, case number CE 20040528, case address 2415 Castilla Isle. Owner, James and Darlene Barron. Property posted 11/10/2020, posted at City Hall 11/26/2020.
Hello?
James, good morning. Can you please raise your right hand? Do you swear and affirm to speak the truth at today's hearing?
Yes.
Thank you so much.
Good morning, Your Honor. Code Officer Snyder, City of Fort Lauderdale Community Enhancement, presenting case CE 20040528 for the property located at 2415 Castilla Isle. This property was first inspected April 30th, 2020 and given 10 days to correct for the following violation. 18-12A, there's overgrowth, trash, rubbish, and debris at this property and or its swale. This is a repeat violation. Previous case is CE-1911-0063. This case shall be presented to the special magistrate for consideration of retroactive fines. This time, the violation was brought into compliance effective November 23rd, 2020. City is requesting retroactive imposition of administrative costs in the amount of $543.
All right. Is it in compliance now?
Yes, Your Honor.
Okay. All right. On behalf of the owner. Someone want to speak on behalf of the owner? Mr. Barron?
Yes, I am also the owner and I am also the developer of the property. In some of these pictures, what you see is there have been some palm fronds on one side of it that were put out for bulk pickup. They were just kept inside the gate until it was time for bulk pickup. One of the pictures shows some fencing and debris, which are from the neighbor's property and the front outside of the privacy wall. We bring the property, it gets maintained about once a month, give or take a week. The property is under 2 permits right now, one for the construction of the wall and the other one for demolition of a new single-family residence. We have been in the city now since February of 2020, trying to address all the comments so we can actually remove the existing residence and start construction on the new. If the city would like me to put up a wall in the front or a construction gate, I'm more than welcome to do that. We just didn't want to put that up until we actually had the permit in hand. But we do have someone that maintains it once a month, give or take a week or so when he comes by. And he's been doing that now for the last several months. We have gotten a citation previously and have spoken to Mr. Snyder. And when we did receive that, we had it taken care of within a few days. The last citation that we got, we actually had the property taken care of about 4 days prior to him posting it on the door, which we had notified him of, but he had did a review of the property prior to that. We didn't know there was a citation at the time because we had already taken care of it due to the monthly maintenance. So we're doing our best to keep it in compliance, and we will maintain compliance. We're just waiting on the city to approve the permits so we can actually remove everything that's there.
Okay, well, we're kind of lost focus here, but I'm going to make a finding to the fact that the violation did exist and impose administrative cost $543.
And how do we go about getting those cleared out now that we're in compliance?
The fine, you mean, sir?
Yes, how do we clear out the fines?
Well, you can remit payment to our admin staff here at the DSD building. Will be available after the hearing today.
No, I'm looking to eliminate the fines and not make payment on them. You and I have had multiple discussions on this being in compliance, and I know you had mentioned one of the neighbors has been complaining. We also have video footage that we're dealing with the authorities on of one of the neighbors dumping trash onto the property on several instances. Those I have not shared with you, but I'll be more than welcome to share with you. But I'd like to find out how to get the fines abated or canceled out without paying them.
Sure. I don't think that it would be appropriate to request a reduction to 0 fines. The magistrate has already ruled on this. The reason I feel that way as the enforcing officer is because, as I mentioned in the presentation of this case, this is a repeat violation. Fines have already been reduced to the administrative cost of just maintaining this case.
Yeah. Okay.
But at your, you may, petition the magistrate for another.
And why are you recommending retroactive fines?
Because
you and I have had multiple discussions of it being in compliance.
Hang on.
Sure, the back and forth isn't really appropriate at this juncture. The magistrate has already ruled.
Absolutely. Okay, next case, please.
Our next case is on page 8, Inspector Will Snyder. Case number CE 20101039, case address 2317, Castilla Isle. Owner Harry Lynette, property posted 11/18/2020, posted at City Hall 11/26/2020.
Good morning, Mr. Garcia. Can you please raise your right hand?
Good morning.
Do you swear and affirm to speak the truth at today's hearing?
Yes.
Thank you.
Good morning, Your Honor. Code Officer Will Snyder, City of Fort Lauderdale Community Enhancement, presenting case CE 20101039 for the property located at 2317 Castilla Isle. This property was first inspected on October 27, 2020, and given 10 days to correct for the following violation. 47-34.4.B.1. There's overnight parking of commercial vehicles and or watercraft at this location. This is a recurring violation. Previous case is CE 19091004. This case shall be presented to the special magistrate for a finding of fact regardless of any achieved compliance. At this time, the violation is in compliance and the city is requesting a finding of fact that the violation has existed.
All right. On behalf of the owner.
Michael Garcia, on behalf of the owner, Your Honor. We don't have any opposition to say that there was a violation. The owner corrected it as soon as he got this last notice. So yeah, the boat was there, but it's been removed and it's not going to happen again.
All right, I'll make a finding of fact that the violation did exist. Thank you.
Thank you, Your
For
Honor.
the same property, there's an additional case on page 12. Case number CE 20100232, case address 2317 Castilla Isle. Owner Harry Lynette, property posted 11/18/2020, posted at City Hall 11/26/2020.
Code Officer Will Snyder, City of Fort Lauderdale Community Enhancement, presenting case CE 20100232 for the property located at 2317 Castilla Isle. This This property was first inspected October 6, 2020, and given 10 days to correct for the following violation: 15-272A. This property is being utilized as a vacation rental property without the required certificate of compliance from the city. This is a repeat violation. The previous case is CE 17020792. This case shall be presented to special magistrate regardless of compliance. The property has remained out of compliance for 30 days. At this time, the property is in compliance. The city is requesting retroactive imposition of fines in the amount of $3,750, which is the sum of 15 days worth of the non-compliance.
Right, on behalf of the owner.
Michael Garcia on behalf of the owner. Special Magistrate, yes, there was a non-compliance. The owner began the process to get the certificate to allow this to be a vacation rental. They decided not to continue with that and withdrew that. They complied with the code enforcement officer where they signed an affidavit stating they will not seek to rent this property out as a vacation rental. We understand there was some non-compliance. We just asked the special magistrate to give us some type of reduction, consideration that they've withdrawn they stopped it, they withdrawn the application, and they've submitted an affidavit stating they're not going to proceed with this.
All right, Mr. Snyder, what's the basis of the request for $3,750 again?
It's the sum of 15 days of 30 days that the property was out of compliance. As I mentioned in the presentation, this is a repeat violation. I believe that the owners of this property have previously submitted for a lien reduction for the very same violation. And to the best of my knowledge, I think it was very lenient. So I'm just requesting about 50% reduction of the accumulated violation. The reason for that is because when I was inspecting this case, I was informed by our admin staff that handles our vacation rental registration that I guess we no longer require an affidavit of compliance as long as all ads can be verified, removed from online sources or print sources. So in consideration of that, I'm just requesting 50% reduction of the fines that accumulated.
All right, I agree with the city's position and impose $3,750.
Thank you, Your Honor.
Thank you, Counselor.
Our next case is on page 13. Inspector Will Snyder, case number CE 20071145, case address 300 Sunset Drive, owner Audi Unison LLC. This property was cited on 9/11/2020 to comply by 9/11/2020. One section not complied at $150 per day, $13,350 accrued. The city requests full amount of fines continue to accrue.
Mr. Audi, please raise your right hand.
Hi, good morning.
Good morning. Do you swear and affirm to speak the truth at today's hearing?
Yes.
Thank you so much. Go ahead, Will.
Thank you. Good morning, Your Honor. Code Officer Will Snyder for City of Fort Lauderdale Community Enhancement, presenting case CE 20071145 for the property located at 300 Sunset Drive. This property was first inspected on September 11, 2020. Citation C0944 was posted to the property implementing a $150 per day fine for the following irreparable violation: 47-21.15.d. The trees at this property have been subjugated to irreparable abuse by hat racking, as defined in section 47-21.2 of the Unified Land Development Regulations.
There are presently no permits on file for a tree replacement at this property, and the violation remains. City is requesting the full imposition of fines, which will continue to accrue.
Okay, on behalf of the owner. Someone going to speak on behalf of the owner?
Yes.
Please do.
Good morning. We have a manager on the site that he made the decision to go ahead and hire a company and trim the trees. Those trees, we didn't trim them. All the big branches was fall during the hurricane 3 years ago. We didn't. The only 3 years ago when the hurricane break most of the trees. And recently, as I mentioned, the manager decided to only trim them because trying to keep them in shape, and he didn't. And the company that he hired, Jose Lawn Service, Fort Lauderdale, they didn't cut any big branches according to them. And we were trying to get an estimate from them, but till today we didn't get it. But not any branches that was cut, not to that required. There were not any branches more than 3 inches was cut. Most of the big branches was broke during the hurricane 3 years ago.
All right. Okay. So you're still not in compliance. Have you talked to Mr. Snyder about coming into compliance?
Yes. First, we didn't know that there's a fine running now every day. There's a fine running every day.
Yes, there is. I posted a citation with the information regarding the fine of the property.
Now, my brother, he tried to reach you many times. Have you spoken to him?
I spoke to one person. I don't recall when exactly I spoke to this person at the property, but I informed him at that time that our landscape plans examiner, Charlie Livio, had evaluated the photos and determined that this was tree abuse by hat racking, and that in order to rectify the violation, permits would need to be pulled to replace the trees at this property or have them removed.
No, we don't want to remove the trees. We like the trees. We respect the trees. And we plant more trees on the property because we like trees. And again, those trees, we didn't abuse them. They were, they were broken because from the heavy wind during the hurricane. Again, and it's not fair right now. We have a fine running for $150 without letting us know about that too. And any paperwork you send us doesn't say that there's $150 fine running too. My brother tried to reach you many times. He left you a message, and it was very hard to reach you to explain to us what we need to do.
Okay, well, I keep my cell phone on me throughout the day, but the $150 fine is clearly written on the citation that was posted to the property and also mailed to whatever your mailing address is listed in BCPA.
Mm-hmm. So what we need to do now right now, please?
All right, here. What we need to do on the record right now is I'm going to rule, and you're free to talk to Mr. Snyder. And I'm not sure you understand what the issues are, but at this point, you're not in compliance. I'm going to impose the fines. They will continue to accrue.
But
sir, right now, there's no but.
The decision is for who's gonna make the decision to tell us what exactly to do.
Okay.
Sir, if you give me a call later today after the hearing, I'll be more than happy to explain it to you and maybe your brother again as well.
And your number, please.
It's okay. Okay, it's 954.
1 second, please.
Okay.
954
325
325
6066. It's my
60.
Yeah, that's my city cell phone number.
Okay. And that's a cell number, correct?
Yes, sir.
Yes, sir. Okay. There's no any way we can stop the
Sir,
fines.
your case has been concluded. Next case, please.
Our next case is on page 14. Inspector Will Snyder, case number CE 201000841, case address 1750 East Los Olas Boulevard, owner 1750 Los Olas Inc. in care of Premier Associates. This property was cited on 10/20/2020 to comply by 11/19/2020. One section not complied at $150 per day. $3,000 is accrued. The city is requesting full amount and fines continue to accrue.
Before we hear this case, I see I have a folder on this information and a long history. Let's take a 5-minute recess.
We're going to take a 5-minute recess before this case. on case CE 201000841 for the property located at 1750 East Las Olas Boulevard. I believe all of our respondents are in the room so that they can start their cameras, unmute their devices so that they can be sworn in.
Good morning. Can you please raise your right hand, including Marie?
Excuse me, is everybody in here? Okay.
Yes, sir. We have Tim, Randy, Dale, William, and Martha, as well as Marie Pierce and
Good morning. Can you please all raise your right hand, including Marie? Do you swear and affirm to speak the truth at today's hearing?
Yes.
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 Yes, I do. Yes, I do.
Thank you.
Yes.
Thanks.
Okay, good morning, Your Honor. This is Code Officer Will Snyder, City of Fort Lauderdale Community Enhancement, presenting case CE 201000841 for the property located at 1750 East Las Olas Boulevard. The property was first inspected October 20th, 2020. Citation C0944 was posted to the property and mailed to the responsible party, allowing 30 days for compliance for the following violation. 47-25.2.L, there are inadequate stormwater facilities and/or systems at this location. There are presently no permits on file for providing adequate stormwater facilities at this property, and the violation remains. At this time, the city stormwater facilities crew leader, Anthony Gigliotti, and Marie Pierce will present and argue evidence of the violation.
Hello, everyone. Can you hear me?
All right. On behalf of the owner.
Magistrate, we're waiting for the expert testimony from the city's representatives. Marie,
Okay.
you can go ahead.
Okay.
Can everyone hear me?
Yeah.
Yes.
Okay, good. So this location dates back many years, dating back to the original complaint that started back in 2015.
Marie,
yes.
I hate to interrupt you, but since the proceedings are being recorded, if you could just state your name and your position with the city.
Sure. I apologize.
That's okay.
My name is Sandra Marie Pierce. I go by Marie, and my position with the city is the Stormwater Operations Manager. If that's sufficient, I will resume. So as I was stating back in, I think it was the fall of 2015, we started to have conversations with this particular location, 1750 East Las Olas Boulevard. And during that time, the city was starting to experience tidal influences and activities to the roadways and causing localized ponding throughout the city, but specifically in this case throughout the Southeast Isles. So for a couple of years, we went back and forth, and in about 2018, I believe, in the spring, the property owner at this particular location embarked on a project to install a tidal valve since they have their own private infrastructure, which is what the video is showing here. They have an outfall, and then they have connecting pipe that goes to, I believe it's 2 catch basins that are located on the private property. And so they went ahead and they constructed and installed those particular that particular tidal valve to mitigate the tidal activity that was coming in from the waterway onto their private property. Incidentally, without the tidal valve, the water would also leave the private property and flow into the city's right-of-way catch basin, which is located at 314 Isle of Capri, which is a property that is just to the south of them. So in about 2019, we started to, it worked for a while and things went well, but then things started to change. And we noticed that we were having the same problem, even though the tidal valve was there. And it's kind of hard to explain in this particular venue, but no particular king tide is the same. And what I mean by that is that the environmental conditions will dictate what type of king tide that you have, starting from the phase of the moon, whether it's a full moon or whether it's a new moon, starting from the groundwater levels and whether they're higher or lower, and then also rainfall. So just to kind of give you a quick and dirty on tidal valves, when tidal valves close, it means that any upland water that is collecting will not drain out if you're during a high tide phase. So in this particular instance, you have a situation that could be exacerbated during a high tide if we happen to have a rain event. So in this particular case in 2019, we started to see the conditions change, and the property owner also was noticing that there was a change in the conditions that they were seeing on their property and with their vehicles. So they had a conversation with myself and with my supervisor, with my manager, Dr. Nancy Gassman, and they were asking me, well, can we abandon can we remove the tidal valve and can we abandon the private infrastructure? And I said, well, sir, I said, that's not within my wheelhouse to do. I said, what you would have to do is you would have to get an engineer on board, and the engineer would have to come out and determine if your drainage calculations support you removing the private infrastructure and or the tidal valve at that particular location. My concern is that the water that collects on your property, whether it's groundwater coming up through stormwater infrastructure that is no longer in good condition, or whether it's coming from rainfall that's collecting and accumulating and then running into the city's catch basin, is that there's a runoff that's occurring. And that is exactly what this particular video is showing. In December of 2019, there was a conversation, and I don't know if he's on the line or not, with a Mr. Gupton, and they had determined that there was a malfunction in their private infrastructure, and they were going to have a contractor come out and CCTV the line and to further assess what type of lining project that they needed to do. Now, I don't know if that was ever done because I don't work in the building department, but I would have to ascertain from the conditions that I have continued to see during the last year and a half that those activities have not taken place. The video that I submitted to code compliance to Will was specifically taken during the months of July. And the reason why I did that is because it was in rainy season, but we were not yet in our king tide season. And I wanted to demonstrate that the water accumulating and running off the property was indeed rainwater and not water that would normally also be associated with our king tide activities. So I think that's pretty much what I have to say at this moment. And so I'll stop talking and let somebody else tell me if they have any questions or if they need additional information from me.
So we're here on a Massey hearing. It's a hearing to impose fines.
Correct, Your Honor. And for the record, Ronald Montoya Hassan with the City Attorney's Office. This was a citation, as the agenda and indicates, with the appeal deadline that had passed. So the city's presentation was to be helpful for informational purposes, but you are indeed correct that it is for, it's a Massey. And then perhaps the property owner can discuss the steps that it is going to take and the time frame for those steps.
Your Honor, I don't mean to appear or sound callous or anything, but I do believe that the respondents did appeal this within a timely manner. I think that's why we're having this hearing.
Yes. Can I speak now? Is it?
All right. Okay. On behalf of the owner.
Yes. I am William Gehring. I am the president of the 1750 Las Olas, Inc., which is a co-op building. We have 20 owners. I'm the president of the board, and we have 3 other board members on the call, as well as our property manager, Dale Clapperson. I would like to first state that we did request this hearing in a timely fashion, as Mr. Snyder just said. So I'm not sure why this hearing states that it's about the fine imposition, because we've never had any sort of hearing on the issue. So we assumed until today, when we saw this agenda, that this was a first time hearing on the situation. So could we clear that up first?
Good morning, Katrina Jordan, Special Magistrate Clerk. My apologies as this does appear in the wrong section of the agenda. So yes, this is an administrative hearing to appeal the citation.
Okay, thank you. So do I continue now, or?
Yes, sir, you may continue.
Okay. I'd just like to correct one statement in what Marie Pierce just testified, and that is that the tidal flooding from our storm drain pipe never cleared up. We had the valve installed in 2018. And actually, I believe it might have been early in 2019. Anyway, there were only, I believe, 2 seasons after the valve was installed of the tidal flooding, and water continued to come up the pipe. So it seemed clear to us that our valve never worked. Because the flooding of Isla Capri and Mola during the king tides is so tremendous, the entire intersection and half of our parking lot becomes like a lake. So it becomes, once the water level rises to a certain height, it's kind of hard to tell where it's all coming from. As you can see in these pictures, the whole place becomes underwater. But we are certain that our valve did not work. So when we were aware of that, and as Marie said, we were, I believe Tim Gupton was contacted by Nancy Gassman about it. We did have the pipe cameraed, and just to backstep a minute, we had been aware of an issue with the pipe several years before all this, and had repairs done to the pipe. I think we spent $3,000 or $4,000 on that. We were aware that there were separations in the seams of the pipe. Anyway, when we did this camera, we found that the pipe was in essence damaged and was allowing groundwater to enter into the pipe, as well as the water from the canal itself, the high tide water. So I spoke with Nancy Gassman several times. I believe Tim Gupton did also. And in our discussions about what to do, we had just recently in 2018, in conjunction with rebuilding our entire seawall along the canal, which is on the other side of the property of the parking lot. And we had the valve installed at that time. We redid the entire surface of the parking lot, which had been asphalt, into pavers, which were intended to be a permeable surface. So, and as you can see in that picture, that we've had a curb put along the edge. And it was a beautiful job. So, so here we are with our brand new parking lot and this old pipe underneath. And so we really, of course, didn't want to rip up the parking lot to put in a new pipe to deal with stormwater, but also we felt quite strongly that such an action would perpetually present the problem of tidal flooding, that a drain pipe going into the canal, now that the sea levels are so high, is kind of inherently bad. So Marie suggested that before we would abandon the pipe altogether, we should get an engineering study. And she gave me the names of 4 or 5 engineering firms. And this is in December of 2019, at which point, and going into January, I called all of them. All of them, I believe 2 of them may never return my call. But the ones that were willing to speak to me had absolutely no interest in doing this drainage study that the city had recommended, that it was too small a job, not that easy to do. And so they didn't really want any parts of it. And one gentleman I spoke with at length from the firm Chen Moore, discussed, possible repairs to the pipe. And he made the statement that he did not think that liners, which was one option to put some sort of plastic liner in the pipe, would work. And obviously we were going to need a new valve because we knew the valve was not working. So then he gave me the names of 2 smaller engineering firms. So altogether, I spoke with about 6 different engineering firms, and none of them had any interest in getting involved in this problem. So we then decided to see what exactly, as our, the concern with the pipe was primarily that it did contribute to the tidal flooding of the entire neighborhood. And we knew that the city had installed these tidal valves on the city storm drain pipes. It was never real clear, this is in the last couple of years, whether those worked or not, because the flooding continued to be so severe. As you can see in these pictures of the flooding were from this year, 2020. So so our concern initially was we got to get rid of this flooding issue through our drain pipe. That was our primary concern. And since engineering firms didn't seem to know or want to do such a study as drainage and water permeation, we decided this would be starting this past January of 2020 to just see what happens when it rains, because stormwater seemed to be the reason the pipe was there in the first place. And what we observed, and these videos we think substantiate in these pictures, that because our property is at such a low elevation, particularly the lowest point of our property is this corner, which would be the southwest corner of the property that you see right there. It sits lower than the street Isle of Capri. Isle of Capri, at this point where our property is, sits considerably lower than Las Olas Boulevard. Las Olas Boulevard, as you go west from where Ala Capri intersects, is an uphill slope to the main, from the aisles of Las Olas to the main business district of Las Olas. So what clearly happens during rains is that water runs down the Isle of Capri, as you see right there in that picture. It immediately goes into our parking area and forms a puddle. And I've owned my apartment in our building for 24 years. And years ago, well, there were several times I believe that Isle of Capri was resurfaced where they would just add more layers of asphalt. And as that happened over the years, this is when our parking lot was still asphalt. During a heavy rain, we would have a very large puddle right along the Isle of Capri that would remain sometimes for 2 days, where you see that white post. It would be all along the entrance to our parking area. And that parking would just sit there, that puddle, excuse me, would just sit there, and you'd drive your car through it. You were always aware that it was there. When we redid our asphalt with pavers, that puddle no longer existed. The rainwater in normal rains dissipates, but the puddle that forms, and in the video that Ms. Pierce showed, where the puddle is very large in our parking lot, we maintain that water is coming off the street. And that was an extremely heavy rain, I believe, the day they took that video, because we have other pictures during pretty heavy rains where the puddle never reaches the area where our old catch basin was. So that a puddle of this size, as you can see in that picture, I believe, the puddle goes all the way out onto the street. So in essence, our argument here is that we do not have stormwater running off onto the city street and city stormwater, that the water originates from the street in the first place. If there was a city storm drain right in that picture, partway down Isle of Capri, we believe that would take the water from the street and it would never enter our property in the first place. Obviously, the puddle has to get pretty deep before it's going to overflow that rock area that you see, which we also put in, and find its way to the city storm drain, because it's very clear that end of our parking lot is lower than the city drain. And one of these, I'm not sure what all we're looking at here, these pictures, but I believe these are pictures that Martha Amesbury took during a heavy rain in November.
Yeah.
But there's a video, I guess that's the video that Dale Clappison took. Couldn't quite tell, it's going so fast. But there was that one, I believe, is showing running water going into our parking lot. And that video Dale took in, I believe it was early November, when there was a city water pipe that broke on Las Olas. And it wasn't even raining that day. It was a sunny day. And his video clearly shows that water runs down Isle of Capri directly into our parking lot. So since it wasn't even raining that day, there's no question that puddle came from the street, not from our property. So we thought that was pretty good evidence of the fact that the rainwater is originating from the street. And I personally took a series of photos, which we had too many to really submit, last February, which was before we abandoned the drain pipe. We did that in March. And we, several of us, went down there when it was raining pretty heavily. And the high point of our parking lot, which is only partway up the property, there was no evidence of water running down the pavers toward that low point. So we felt quite comfortable that the pavers were allowing the water to permeate into the ground and not flowing towards the drain. So our conclusion was, as a storm drain, that was no longer necessary on our property, and the potential damage of a pipe that opens into the canal with a valve that could always get jammed. If the tidal valve worked, it would keep the canal water out and not flood. But we were concerned about how would we ever know if the valve was working properly or not. You can't really get to where it is to inspect it. And so we felt quite comfortable in our decision to abandon the pipe altogether, and which we did last March. We were hopeful that when the king tide season came around this fall, starting in September, that the city's tidal valves on the city's storm drains would be functioning properly. And we were very confident that we would no longer be contributing to the tidal flooding as our pipe was eliminated. But lo and behold, the king tide flooding this fall was perhaps worse than it's ever been. And we understand from Nancy Gassman that is because Mola, the street that forks off of Isle of Capri, has a serious problem of being below sea level or something to that effect. So that, as you can see in that picture, what happens is the city has to bring in temporary pumps. You see it in that picture right there, because the whole place is underwater, and including about a third of our parking lot, we have to have cars moved out to the front of the property to get them out of the water. I guess our defense is that we are not in violation, as this citation suggests, that there is no stormwater runoff from our property. In fact, it's the opposite. The water runs on to our property, and there really is no remedy, or the citation says corrective action is to provide adequate stormwater facilities and systems. Well, we don't know what that would even be, because we don't think a drain pipe into the canal is at all a good idea with the continuously rising sea levels that we have. And we did speak with a different engineering firm. Dale Clappison and I spoke with them, Caulfield and Wheeler, who are from Boca, and they suggested that there really wouldn't be any, if we did have a stormwater issue on our property spilling off into the city system, that because of our extremely low elevation, there's really not a whole lot that we could do about it. And so, and I did submit a written 2-page summary of all this, which I don't know whether the city representatives have seen that or not. But it kind of, I think it reiterates pretty much everything I said. I would like to point out one item from my written response, which is at the bottom of page 1, that in the early discussions of all this flooding problem and water control, there was an email from Ilkin Diaz, a public works project manager, talking about the problem of the flooding on Isle of Capri and our property and so forth. And he stated, and I quoted in here, that various inspections also confirmed that runoff from the state-owned drainage system of Las Olas Boulevard contributed to the Isle of Capri flooding. So we feel that reiterates our point that water running down Isle of Capri from Las Olas is the cause of any problem. And the city's video, while it shows a very large puddle on our property, I think you can see at the beginning of that video the tremendous amount of water that is on Isle of Capri. It just doesn't, it's not focused enough to show that it's flowing into our property, but that's what it's doing.
All right, I got to interrupt you here. I'm hearing a lot of things, and I'm trying to simplify it, and I'm trying to put it in perspective. And let me call on Ms. Montoya again, because this was a citation that was issued, correct? And there was a time frame of November 4th, 2020 to appeal the citation, correct?
Yes, sir. And I understand from staff, it was incorrectly put on the agenda that the property owner did timely appeal. So the posture of the citation would be that the appellant has the burden to show that the citation was issued in error.
Could I speak? And maybe you can clarify. We received one citation that was issued incorrectly, citing,
Which one do you need?
and then a new one was issued. So I don't know whether the dates are confusing the problem.
Sir, Your Honor, if I could add clarity to all of this, please. Initially, when Marie Pierce asked me to go out and to evaluate and issue an inspection report, the original violation was for stormwater runoff the property. We did try to move forward with that, but I think that as king tide season approached, it became clear that the issue with the property wasn't runoff, or at least it wasn't something that we could garner sufficient evidence to, I guess, pin to the property, for lack of a better term or phrase. After we had repealed the initial inspection report, and we opened a new violation under this present case number, and it was for an entirely different violation. The violation under consideration here is 47-25.2L for inadequate stormwater facilities being provided at this property. Now, when I think that the situation with this area is actually rather tragic. I've seen evidence of stormwater running off the city right of way onto their property. I've seen evidence of pooling on their own property because of stormwater, but I've also seen evidence of stormwater coming up through the catch basin, through bubbling. And I wish I could provide that evidence. Unfortunately, it was corrupted during the transfer process, and I no longer have those photos, and king tide season is no longer here. I think that it would be wise for the city and the neighborhood to, instead of, be combative, to come together to try to fix the problem. But at the same time, I do feel that the citation that was issued is present, and it does prove that there is a violation at this property and that it's inadequate stormwater facilities provided.
May I speak?
Yes.
My name is Tim.
Oh, please.
My name is Tim Gupton. I'm a resident of 1750, and I've been working with the board since 2017, when the city began the whole process of addressing rising water on the throughout the city. And one important thing I think, Your Honor, to understand is we immediately got on board. We went to the public meetings. We met with Nancy Gassman and her staff. We immediately raised our seawall. We installed a tidal valve. When that didn't work, we chose to fill the drainage pipe in order to mitigate the rising tide issue. And we installed the permeable parking lot and a rock pit next to Isle of Capri, all at a cost of about $100,000. So in that process, I learned that the city had designated this area as a major problem. And in fact, there is no stormwater system in this corner of the neighborhood. There are two drains that lead to one tidal valve. There's no stormwater removal system that exists in this area. And that's what's supposed to be addressed as part of the city's bond issue. And the project is on, in the queue, so to speak, to be mitigated because of the MOLA and the Isle of Capri, serious issues surrounding us. So it doesn't really make any sense for us to try to fix a alleged problem when the problem is really, really much, much bigger than this. And if after the city installs their stormwater system and addresses the runoff as well as the top issues, and we still have a problem, then we're more willing at any point to fix that. But this is just not this is not the problem. The problem is much bigger than this.
And Your Honor,
yes,
the respondent just mentioned that there are no stormwater facilities at this property. This is precisely the violation that we had decided to cite them for. Myself and my supervisor, Stephanie Bass, reviewed this case, and we determined that it wasn't so much a runoff issue as much as it was there's no facilities at all. And that's the violation. That's what was cited.
Well, your citation says that we're improperly draining into the city's stormwater system. There is no city.
No, sir, that's not what it says.
You're looking at the previous inspection report. I issued citation C0944 to that property, which is code section 47-25.2L, and that code section reads specifically, there are inadequate stormwater facilities or systems at this location, and that's the violation.
So it's a finding of fact whether what we've done is adequate for the stormwater, and it doesn't address the fact that the city doesn't have any stormwater system at that location and will not until this big project is done.
We're not going to argue on that. We're here to talk about the appeal of this citation.
Right.
Yeah, well, we maintain, and I think your video clearly shows a big puddle on our property. It also shows, if you look at the tail end of it, that the house behind us, whose driveway sits right on top of, or right next to the storm drain opening, the catch basin, that water is flowing down that guy's driveway right into the drain. So the only time that water is going to leave our property and go into that drain is when the puddle becomes deep enough that it's at the same elevation as the city drain, which sits higher than our property.
Again, sir, this is not about runoff. This is about whether or not you have adequate stormwater facilities at that property, and you do not.
Well, what would be adequate if we don't accumulate stormwater on our property because it's a permeable surface? Then,
Your Honor, if I could, I would just say I'm not sure how productive the back and forth is on this violation. I believe you've heard from the city's stormwater manager as to the conditions and the inadequacy, the lack of proper stormwater facilities or systems. You've also heard from the property owner with anecdotal evidence without any engineering report or engineering analysis or engineering testimony with regard to the substance of the citation. And respectfully, I would ask Your Honor if Your Honor would either consider taking it under advisement or ruling on the appeal of the citation.
I'm sorry, repeat that last part.
I said, Your Honor, I would just respectfully ask if you could rule on the appeal of the citation, and Your Honor may want to take it under advisement and read the documentation again submitted by the property owner, and or review the testimony again. I know a lot was said today, but I'm not sure how productive this back and forth is at this juncture.
And
unless, of course, you have any questions of the city's stormwater manager.
I, quite frankly, I'm a little bit overwhelmed. I'm trying to keep this in a legal perspective, and also understand the positions of the parties. I feel like I'm missing a lot of professional input, possibly from on behalf of the property owner. They seem to be saying that they can't fix this. Is that what you're saying? Is
We're saying two things. One is I guess initially is that we are convinced just from on-site visual observation repeatedly that the rainwater, stormwater issue on our property is because it runs onto our property from the city streets. And we don't feel that we should have to control that.
Right.
But Bill, we tried to control it. We put in the pavers, right? We spent $63,000 putting in pavers so that any stormwater would go through the pavers. And we also spent thousands of dollars building a drainage pit right on the corner there. But so much water comes in down from Las Olas, down Isla Capri, and also from Mola. You know, it's like the perfect storm. It all converges and it runs right into our property. So, you know, we have spent thousands of dollars trying to mitigate this problem already.
all right. Here's what I'm going to do. I'm going to got your paperwork. I'm going to reset this matter until Thursday, January 14th, 2021. Okay. All right. I'm going to try to get a handle on the engineering issues and the legal issues. All right. So this is reset till Thursday, January 14th, 2021.
Thank you.
Thank you.
Thank you.
Is a suggestion is apparently the property has discussed this with multiple engineers, and as I understood what you said, nobody wants to get involved in trying to fix it. And
well, the request by the city was that we have a study done of the drainage capabilities of our property, and nobody really, none of them wanted to do that. Too small a job and difficult to prove, I guess. I'm not sure. But the most recent firm, which spoke with us more than anybody else, they discussed in what would they actually do to try to comply with this department's request, was that they would have to do some sort of a elevation study of the property and 3D survey or something. And but the bottom line was that if they did determine that there is water runoff, that our property needs some sort of stormwater management, that there really aren't too many options available for us to handle it. So I think the city's position is that the fact that we filled in this drain, which was never really doing much to eliminate stormwater in the first place because of where it was, and the fact that it was causing so much damage during the high tide flooding.
all right. Okay. Ms. Pierce, you wanted to say something.
Is it appropriate for me to add to at this point? I'm not really familiar with, I'm an operations person, so I'm not really familiar with the special magistrate process, and I don't want to say something incorrectly.
Yeah, I think your input would be appreciated. We've heard.
Sure, not a problem. So how this works in stormwater is, in today's world, when you have a private property and you are constructing your property in Broward County and the city of Fort Lauderdale, you have to apply for what's called a surface water management license. And in doing so, you demonstrate that you are capturing your rainwater on your property and that you're not allowing that water to leave your property. So the particular location that we're speaking about today, 1750, was constructed at a time when surface water management licensing did not exist in South Florida. And that started in the late 90s, specifically in 1998. So anything that predates 1998, including city facilities, will not have that quote unquote surface water management license attached to it. However, whenever they go through renewal processes or they go through renovations, if they meet the thresholds, then they have to apply for that license and become compliant. Now, whenever they put the drainage system in, they would have had to go through permitting, and they would have had to demonstrate that based on the drainage calculations, and that's the word that you're looking for, Mr. Goldring, is that's what an engineer does. An engineer factors in everything on the property, everything on the right of way, and determines where the water is coming from, and makes sure that we design, or that they are designed, a project at that particular location that will meet the needs of the property. So I can't speak to the timeline of the private property, but I do know at some point private infrastructure was installed there. So somebody had to come up with a plan that put it there. And in turn, when you abandon drainage, you're supposed to do the same thing. And my concern is that, and the video that I took in July demonstrates it, that water is running off of the property, down the right of way, and into the catch basin at Isle of Capri. I don't know what video that we're looking at here. The one that the number that I saw that came up was in October, so I don't think that's the video that I submitted. So perhaps we can revisit that. I know that it was sent over to Will and to Stephanie, and I don't think this is the appropriate forum to have that discussion. But again, my concern is that whenever they made the decision, when the property owner made the decision to abandon the infrastructure, they did not go through the proper process. And the proper process means that you hire an engineer, the engineer comes in, looks at your property, provides drainage calculations, and determines before you abandon and seal off that outfall and close up that pipe, that you can retain your water on site in a safe manner. And that clearly is not happening. I'm not going to, I will be transparent and compliment or echo what the property owner is saying, that there are issues that exist on Isle of Mola and, Isle of Capri and Mola Avenue. And that involves a private seawall that is also being worked through with the Public Works Director and that property owner. So we're hoping to mitigate some of that. The secret to all of this, whether it's rainwater or tidal water, is that water finds its own level, and it will always go to the lowest point. And that's just how the physics of water works. But in this particular case, the property owners at 1750 East Las Olas, whenever they made a decision to abandon their infrastructure, they did not go through the proper process. And at this point, at least from what I have seen during rainwater events, tidal activity always complicates matters, but during rainwater events, I have witnessed and I have videoed water coming off of the private property, running down the side of the street into the city catch basin. And that's really, I mean, I have two aims here. One is to make sure that streets are drivable for all of the City of Fort Lauderdale residents. And the Stormwater Master Plan will go a long way in doing that. But it's also to make sure that the imaginary lines or the boundaries that are created through our private property parcels and our right-of-way parcels are delineated to the extent that they can. And at this point, based on the inadequate infrastructure that we have at 1750 East Las Olas, that is not happening. And I hope that helps.
Yeah, but that puddle is so small. I can't imagine. First of all, water doesn't flow uphill, okay? So I'm not sure how you got your video to show that the water is flowing from our puddle down the street.
Ma'am, hearings do not work that way. Okay, you don't get to direct comments to city witnesses. That's not how this process works.
Okay. I'm encouraging communication between the city and the property owner. But again, this is continued and will resume January 14th, 2021. Thank you.
Thank you.
Thank you. Our next case is on page 4. Senior Inspector Dorian Cologne, case number CE 1905181, case address 2510 West Broad Boulevard, owner NBIM Riverbend USLP in care of Northbridge Investments Management, Inc. Property posted 11/5/2020, posted at City Hall 11/26/2020.
Page 4, bottom.
Good morning, Bob. Microphone is muted. Good morning, Bobby. Please raise your right hand. Do you swear and affirm to speak the truth at today's hearing?
Yes.
Thank you.
Hi, good morning. Senior Inspector Cologne with the City of Fort Lauderdale. Case number is CE 1905-1821. The case address is 2510 West Broward Boulevard. This property was first inspected on May 22nd, 2019, and the following violations were observed. 47-20.14A, there are lights in the park and facilities that are not illuminating and or are not bright. 47-21.16.A has been complied. 47-22.9 has also been complied. Pre-hearing inspection was conducted on December 7th, 2020, and all the violations are in compliance with the exception of 47-20.14A. A recent night inspection was conducted by Inspector Del Grasso to inspect the lights. And the lights, there were some lights that she noted. There was approximately at least 11 lights that were not working at all. And then there were others that were not bright enough and meeting the minimum requirements of illumination. The city is requesting 28 days to comply or $50 a day thereafter.
All right, on behalf of the owner.
Hi, my name is Bobby Schwester. I represent the ownership through a property management company of Sandstone Group. At the time of the original code violation, there was one pole light that was out that had been since fixed. With the new inspections, yes, there are plenty of lights out. We currently went through GE to get warranty fixtures mailed out. That took about 2 months, unfortunately. And they were said to be put on a truck on the 7th of December. So as soon as I get all those fixtures in for GE, everything will be replaced and everything will be back up and bright, and we'll be able to remove our temporary lighting towers.
Okay. All right. And for the record, I found the violation does exist. 28 days to comply, $50 per day thereafter. Thank you.
Thank you. Thank you.
Respondent, Mr. Rogowski, do you have a case on today's hearing? Again, Mr. or Ms. Rogowski, do you have a case that needs to be heard on today's agenda? If not, we're going to move on and call our non-respondents.
Yes.
We will now begin to call the cases with no respondents. Our next case is on page 1. Inspector Bovary Exantis. Case number CE 20040535. Case address 1213 Northwest 17th Street. Owner McGrath Group, Inc. Property posted 11/19/2020, posted at City Hall 11/26/2020.
Good morning, Your Honor. Inspector Exentis, on behalf of the City of Fort Lauderdale Community Enhancement, case number CE 2004-0535, property address 1213 Northwest 17th Street. This property was first inspected on May 1st, 2020 by Senior Inspector Linda Holloway. The following violation was observed: 9-304B. There are vehicles, trailers parked on the unapproved grass lawn area. The gravel driveway is not being maintained. There are areas of the gravel driveway that are missing or worn through, and there is grass going through it. A notice of hearing was posted on the property on November 19, 2020, and the pre-hearing inspection was conducted on December 5th, revealed the violation remains as depicted in the photos. The city is requesting 34 days to correct or a fine of $50 per violation for each day thereafter.
I find the violation does exist, 21 days to comply, $50 per day thereafter.
Thank you, Your Honor.
Thank you.
Our next case is on page 2, Inspector Boverick Xantis. Case number CE 20080428. Case address 1540 Northwest 11th Way. Owner Rodolfo Gutierrez and Judith Gutierrez. Property posted 11/19/2020. Posted at City Hall 11/26/2020.
Good morning, Your Honor. Inspector Exentis, on behalf of the City of Fort Lauderdale Community Enhancement, case number CE 2008-0428, property address 1540 Northwest 11 Way. Property was inspected and the violation were observed. 9-313.A is complied. 9-305B. The landscape at this property is not being maintained in a neat and well-kept appearance. There are areas of dead and missing ground cover. Violation 18-18. There are chairs, table, washing machine, and coolers and other miscellaneous items stored on this property, creating a public nuisance and is an eyesore. Violation 47-34.1.A.1. There are under roof storage chairs, table, washing machine, cooler, wood, ladder, and other miscellaneous items stored on the property. Violation 18-4C. 18-4C. There are vehicles. There is a derelict vehicle or trailer on the swell and on the property. Hearing inspection was posted on the property on November 19, 2020, and violation remains, and the city is requesting 63 days for the violation to apply or fine of $50 per day thereafter. Actually, 62 days for each violation, $50 for each violation, or a fine of $50 for each violation thereafter.
I find the violations do exist, 62 days to comply, $50 per day thereafter.
Thank you, Your Honor.
Thank you.
Our next case is on page 3, Inspector Roberta Jones. Senior Inspector Leonard Champagne presenting case number CE 20020270. Case address 824 Northwest 15th Avenue. Owner YN Investments LLC. Property posted 11/20/2020. Posted at City Hall 11/26/2020.
Good morning, Your Honor. Leonard Champagne for the city, for case presenting for Roberta Jones at 824 Northwest 15th Avenue, CE 2002-0270. This property was first inspected on February 8th, 2020 for the following violations. 9305A, there is growth of landscaping material along with the accumulation of leaves encroaching upon the property, public right-of-way. 9305B, the landscaping at this property is not being maintained in a neat and well-kept appearance. There are areas of dead and missing ground cover. 9304B, the gravel driveway is not being maintained. There is grass and weeds growing through the gravel, and the gravel is worn through in some areas. And 9306, the exterior building walls and fascias have not been maintained. There are areas of the exterior that have stains and missing peeling paint. 1812A, there is overgrowth, trash, rubbish, and debris on this property and or on the swale. And 9278E, every inhabitable room shall be ventilated to the outdoors. There are windows that have wood on the windows themselves. Okay. None of those violations have been complied. As of the last inspection on 12/5/2020, the city is requesting 14 days for each violation and $50 a day per violation thereafter, with a compliance date being of 12/23/2020.
Each violation does exist, 14 days to comply, $50 per day thereafter.
Thank you, Your Honor.
Thank you.
Our next case is on page 4. Senior Inspector Doreen Cologne, case number CE 1901071. Case address 548 Southwest 27th Terrace. Owner Michael Sternamalo. Certified mail was received this property on 11/7/2020 and posted at City Hall on 11/26/2020.
Good morning. Is Senior Inspector Cologne with the City of Fort Lauderdale. Case number CE 19010731. Case address 548 Southwest 27th Terrace. This property was first inspected on January 10th, 2019, and the following violations were observed. 9-313A, house numbers are not clearly visible from the street and or properly displayed on this property. 9305B, the landscape at this property is not being maintained in a neat and well-kept appearance. There are areas of dead and missing ground cover, including the swale area. 9304B has been complied. 47-34.1.A.1, there's outdoor storage consisting of buckets, containers, PVC, wood, barbells, cones, water jugs, ladders, toolboxes, tools, equipment, paint cans, garbage cans, and other miscellaneous items on this property in the front, on the sides, and in the rear. This is a non-permitted land use in this RM-25 residential zone district per section 47-5.19. A pre-hearing inspection was conducted on December 7th, 2020, and it shows that the violations remain as depicted on the pictures. The city is requesting 21 days to comply or a fine of $25 a day thereafter.
All right. I find that each violation does exist, 21 days to comply, $25 per day thereafter on each.
Thank you.
Our next case is on page 5. Senior Inspector Doreen Cologne, case number CE 19051808. Case address 2500 West Bar Boulevard. Owner 170 Northeast 40th Street, Inc., in care of Steve Rhodes. Property posted 11/5/2020. Posted at City Hall 11/26/2020.
Good morning, Senior Inspector Cologne with the City of Fort Lauderdale, case number CE 1905-1808. Case address is 2500 West Broward Boulevard. This property was first inspected on May 22nd, 2019, and the following violations were observed. 47-20.14.A, there are lights in the parking lot, in the parking facilities that are not illuminating and or not bright. 47-21.16A has been complied. 47-22.9 has been complied, and 9305A has been complied. A pre-hearing inspection was conducted on December 7th, 2020, and all of the violations were in compliance with the exception of 47-20.14.a. The city is requesting, 28 days to comply or $50 a day thereafter.
I find the violation does exist. 28 days to comply, $50 per day thereafter.
Thank you.
Our next case on page 5, Inspector Matthew Miller, case number CE 20090377, case address 2080 Southwest 37 Terrace, owner Cerebrus SFR Holdings 2 LP. Personal service was given to this property on 11/22/2020 and posted at City Hall on 11/26/2020.
Good morning, Your Honor. For the record, Matthew Miller, City of Fort Lauderdale Code Compliance Inspector. This is going to be presenting case number CE 2009-0377 for the property located at 2080 Southwest 37 Terrace. Senior Officer Garcia first inspected this property on September 11th, 2020, and cited for the following violation: 9-305B. This was complied. 9-280H1. The fence at the property is in disrepair and is not being maintained as required. On November 3rd, 2020, a reinspection was performed by myself and observed that the fence remains in disrepair. A request for special magistrate was sent to the code administration. Notice to appear was posted on the property on November 22nd, 2020. Re-inspected property on 12/7/2020, and I observed that the fence remains in violation as the photos depict. Contact was made with Ms. Ortiz, who identified herself as the community compliance coordinator for First Key Homes LLC. Ms. Ortiz stated to me that they are aware of the violation and working to get compliance. The city is requesting 28 days to repair the violation. If not in compliance, the city requests to impose a fine of $100 per day until violation has been cured.
I find the violation does exist. 28 days to comply, $100 per day thereafter.
Thank you, sir.
Our next case is on page 8.
Oh, I'm not going to mute.
Inspector Will Snyder, case number CE 20100277, case address 1923 Northeast 33rd Avenue, owner Ina Zelendez, property posted 11/4/2020, posted at City Hall 11/26/2020.
Good morning, Your Honor. Code Officer Will Snyder, City of Fort Lauderdale Community Enhancement, presenting case CE 20100277 for the property located at 1923 Northeast 33rd Avenue. The property was first inspected October 7, 2020, and given 10 days to correct for the following violations: 24-27B. There are trash containers left roadside overnight after collection day and not pulled back to an approved location. This section was brought into compliance on October 28, 2020. And also for the violation of section 18-12A, there's overgrown trash, rubbish, and debris on the property and/or swale. City is requesting 14 days to correct the remaining violation, or $50 per day for each day thereafter.
I find the violation does exist. 42 days to comply, $50 per day thereafter.
Thank you, Your Honor. Take care, everyone.
Okay. All right. 14 days to comply, $50 per day thereafter.
Our next case is on page 9. Captain Robert Kasarwich, case number FC 20020019, case address 631 Northeast 8th Avenue, owner 631 Northeast 8th Avenue LLC, property posted 11/19/2020, posted at City Hall 11/26/2020.
Katrina, Captain Kasserich says that that case is complied.
Thank you. Our next case is on page 13. Case number CE 201000377 has been withdrawn. The city would like to enter page 18 into the hearing as an exhibit. It is the city's list of compliant, closed, withdrawn, and rescheduled cases.
So we're done. All right. Everyone, have a great holiday. Stay well, stay healthy.
Happy holidays, Your Honor.
Rhonda, can you hear me?
Yes, sir.
I have something I hope you have one day.
Thank you. You too. We'll see you in 2021, which will hopefully be a better year.
Hopefully. Happy holidays, Your Honor. Happy holidays, everyone.
Rhonda, it's my 50-year pin.
That's awesome.
Born into the bar 50 years ago last month. Makes me feel old.
Not at all.
Okay. Okay, so ordered.
This concludes the special magistrate agenda virtual hearing for December 9th, 2020.